You know, the criminal court process, it can feel like this huge, intimidating maze, especially in a big city like Atlanta. So what we're going to do today is lay out a clear roadmap. We're going to demystify the whole thing, so by the time we're done, you'll get how it works from start to finish.
Right, we've all seen it on TV. The dramatic lawyer points a finger, a surprise witness bursts through the door. But what really happens after an arrest? Well, the truth is, it's a lot less Hollywood and a lot more, structured. It's a process. So let's break down the actual step-by-step journey.
Okay, so here's our game plan. First, we'll look at the court map itself. Then, we dive into those super critical first 72 hours. After that, we'll see how a case gets built, piece by piece. We'll hit that major crossroads, plea deal or trial. Then, the verdict and what comes next. And we'll wrap it all up by talking about the rights you have through this entire thing.
All right, section 1. So first things first, you got to understand where a case even begins. Not every case just lands in the same big courtroom. No, it's more like a sorting hat. The type of crime, how serious it is, that's what decides which court gets the case right from the get-go. And this table here, it lays it all out pretty clearly. You've got the municipal court for things like city ordinance violations or traffic tickets, kind of the ground level. Then there's the magistrate court. Think of this as the main entry point for most arrests. They're the ones issuing warrants and handling those first bail hearings. Step it up a notch and you're in state court, which handles misdemeanors like DUIs. And then you have the big one, superior court. That's where all felony cases go, the ones that might end up in front of a jury. Okay, now we're getting into the really time-sensitive stuff. The first 72 hours. The second an arrest happens, boom, a legal clock starts ticking. And believe me, the next 3 days are absolutely packed with critical moments that can shape the entire case.
So, what even allows an arrest to happen in the first place? It all comes down to this one legal standard, probable cause. And this isn't just a gut feeling or a hunch an officer has. No way. It means they have to have a reasonable belief based on actual, verifiable facts that a crime was committed. It's literally the key that starts the engine for this whole process.
Look at this timeline. You can really feel the pressure, right? At hour 0, the arrest happens. From that moment, prosecutors have only 48 hours to get their act together and file formal charges. And then, between 48 and 72 hours, the person who is arrested must be brought before a judge for what's called a first appearance hearing. The clock is non-negotiable.
And a huge part of that first appearance is dealing with bail. The judge is looking at things like, is this person a flight risk? Are they a danger to the community? And based on that, they'll pick an option. It could be a straight-up cash bond, or maybe a property bond where you put up your house as collateral. A lot of people use a surety bond, which is when you go through a bail bondsman. And sometimes, if the judge thinks you're reliable, you might get release on recognition. That's ROR. It basically means you're released on your promise to show up for court, no cash needed.
Okay, so the first 72 hours are over, bail is set. What's next? Well, now the case shifts gears and moves into a new phase. This is where the real legal work begins, with both sides starting to build their case and dig into all the evidence.
The next big court date is the arraignment, and it's important to know what this is and what it isn't. It's not a trial. Nobody is arguing the facts yet. This is simply where the defendant stands before the judge, hears the official charges against them, and has to enter a plea. The main options are guilty, not guilty, or a less common one, nolo contendere, which is Latin for no contest. It's kind of like saying, I'm not going to fight this, without actually admitting you did it.
Once a plea is entered, we get into a really fascinating part of the process called discovery. And the core idea here is simple. No surprises. The prosecution can't just hide its cards until the trial. They are legally required to share all of their evidence with the defense. We're talking police reports, witness statements, body camera footage, the whole shebang. It ensures a fair fight and prevents what lawyers call a trial by ambush. So now the defense has all this evidence from discovery. What do they do with it? Well, this is where they can make some serious strategic moves by filing pretrial motions. And these are really powerful. A lawyer might file a motion to suppress evidence they think was gathered illegally, or they might ask the judge to completely dismiss charges that have legal defects. And get this, if you win one of these motions, it can cripple the prosecution's case, sometimes ending it right then and there, long before a jury is ever involved.
And all of this leads to a massive fork in the road. I'd say this is probably the most critical decision point in almost any criminal case. The evidence is out, the motions have been argued, and now the defendant has to make a huge choice. Take a plea deal or roll the dice and go to trial. And before you imagine a big courtroom battle, look at this number, 90% plus. That is a staggering statistic. It tells you pretty much everything you need to know about how the system actually works. Over 90% of criminal cases, they don't go to trial. They end with a plea agreement.
So why? Why is that number so high? Well, look at the comparison. A plea agreement gives you certainty. You know what you're getting, often with lesser charges and a set sentence. For the system itself, it's also how it keeps from getting completely gridlocked. But going to trial? That's a total gamble. It's high risk, high reward. You could walk away completely free, acquitted of everything. But if you lose, you could face a much, much tougher sentence than what was in the plea offer. It really boils down to a huge strategic decision.
But what about that other 10%? For the small fraction of cases that actually do go to trial, the whole process gets way more formal and structured. This is the main event, where all the evidence is finally laid out for a jury to hear and a final verdict is reached.
And a trial really does follow a strict script. First up, you have to pick the jury. Then you have opening statements, where each side lays out their version of the story. The prosecution goes first, presenting their entire case. Then it's the defense's turn. After all the evidence is in, you get the closing arguments, the lawyer's last chance to persuade the jury. And finally, the jury goes off to deliberate, and they have to come back with a unanimous verdict. Every single one of these steps is mandatory.
So what happens after a guilty verdict, or after someone takes a plea deal? The case moves to sentencing. And the judge has a whole range of options. It could be fines and restitution, community service, probation, or, of course, incarceration in jail or prison. But here's something really important to remember. For certain crimes, there are mandatory minimum sentences. And that means the judge's hands are tied. They have to impose at least that amount of time.
And even after sentencing, the legal journey might not be over. There are still options, like filing an appeal to a higher court or asking the judge to modify the sentence. But, and this is a big but, these aren't open-ended. They are governed by super strict, legally binding deadlines. You miss one, and that door closes for good.
All right, that brings us to our final section, and honestly, it might be the most important one, because running through this entire process, from the moment of arrest to the very end, is a constant: your rights. These are the constitutional protections that act as a safety net at every single step.
And this right here, it's arguably the big one. At every stage, defendants have the right to be represented by an attorney. That's not just a suggestion, it's a guarantee. From the arrest to the trial, all the way through an appeal, you have the right to a lawyer. They're your guide through this entire complex maze we've just been mapping out.
So let's just recap the fundamental toolkit of rights. You've got the right to remain silent so you don't have to incriminate yourself, the right to an attorney, which we just covered, the right to due process, which is a fancy way of saying the government has to follow the rules and treat you fairly, the right to challenge evidence brought against you, and of course the right to a fair trial by a jury of your peers. These are the bedrock safeguards of the entire system.
So there you have it. What starts as a potentially chaotic moment on the street, an arrest, transforms into this incredibly structured journey through the court system. It's not random. It's a map with clear rules and established rights. And just knowing what that map looks like, that's the most important first step for anyone trying to navigate it. Which leaves us with one last big question to think about. We've seen that the process has a ton of rules. It's a map designed to be fair. But is a fair process always the same thing as a just outcome? That's something worth thinking about.